Hello, friends. Very warm good evening to all. This is Sangam Aggarwal, and I welcome you in another session on very important and special topic of intellectual property rights. So today we have our very special guest, Advocate Bhave Goyal, and moderator of the session, CA Shubham Goyal Aggarwal, who will moderate this session and also share his experience over this IPR and some GST aspects related to IPR. So friends, as you know that we are conducting these sessions for you, and IPR is another sessions today we will organize. The purpose of organizing this session is very important, friend. And as we know that our all the professionals are facing some business crunches due to COVID-19 and lockdown. So friends, the purpose of organizing this session to motivate our all professionals to inform them that IPR is another area of doing practice, how we can motivate our clients, guide them, and help them to get the IPRs like trademark, copyrights, and other things. Because in IPR, the many things are involved on which Bhaveji will discuss in detail. But friends, truly speaking and frankly speaking, if we guide our clients timely the importance of trademark and IPR, it definitely helps to grow their businesses. Because generally in starting, people are not care about their trademarks, but once their name and goodwill set up, at that time, generally they have a dispute related to their brand names. So trademark is very important, and somehow it is a duty of all the professionals to guide their clients. Generally, friends, what I saw in my past experience, people not come to you and say kindly do the trademark, and you have to identify your clients and guide them. That's why you are required to get trademark so that in long term you get the benefit of trademark. So somehow, friends, it's a duty of all the professionals to generate the professional work for all of us. So to know about this, we have Advocate Bhave Goyal. And friends, I request you, you want to ask your query questions, you can ask in the comment section. We will take your all the questions at the end because in last 10 minutes we have a session on Q&A. And friends, apart from that, whatever material we will share as soon as we'll get from the learner speaker, we will share the link to download such material in our comment section. You can download from there. And friend, I request you kindly subscribe our channel and click on the bell icon so that you can get the information of upcoming sessions, and you can also watch our previous sessions. We have more than 55 recorded session on our YouTube channel. You can watch that and enjoy that and share the feedback with us. And friends, I will not take much time and now going to read the profile of Advocate Bhave Goyal. Bhavi Goyal is an advocate and an IP attorney, registered patent agent based at New Delhi. With 5 years of experience, he has specialized in the intellectual property laws, corporate advisory, and litigation, besides having an extensive experience of handling prosecutions for more than 4,000 trademarks. So, friends, kindly mark the figure 4,000. That shows he has a very good experience in litigation. 4,000 trademarks, patents, copyright, design, application. He has advised numerous clients ranging from startup to Fortune 500 companies on various issues, including without limitation IP law, company law, consumer protection law, RERA, alternative dispute resolution, criminal law. He has successfully handled numerous continuous litigation before various courts and tribunals in India. He is a member of Delhi High Court Bar Association. His education includes biotech engineering degree from MIT University and advanced course of biotechnology and intellectual property from WIPO, a post-graduate diploma in patent law from Nalsar, and a law degree from prestigious faculty of Delhi University. So, friends, I think his profile is enough in itself, showing the experience of Advocate Bhavi Goyal. So, friends, I request all the participants kindly take this session as a very important session for growing their practice. And before going to start, I request CA Shubham Aggarwal to share some word of wisdom before starting this session. Over to Shubham ji.
Thank you, Sangam ji. Bhavya is my very dear friend from the days of Faculty of Law, Delhi University. We know each other since around 7 to 8 years, and we have been referring each other a lot of work related to our respective fields. So I can totally vouch that Bhavya is an expert in his field. related to intellectual property rights, trademarks, and copyrights. And it is always an honor to listen to what he speaks. So, without taking much time, I'll request Bhavya to kindly continue and start his deliberation on the session today. Over to you, Bhavya.
Thank you, Shubham. Thank you so much. Thank you, Sangamji. Thanks for the kind introduction you guys have given me. And I really feel honored to be here on this platform and speak about intellectual property. So I believe most of our viewers are professionals. So I would like to start the session by giving them the incentives of the government, which they can use to, tell their client and help their clients. Because nowadays you'll see most of the clients are in a mode where they want to make the best out of their money. They're looking for value for money deals. So, friends, I would like to tell you first of all that there are two major schemes which most of the people are not aware of in the market. First scheme is Startup Intellectual Property Protection Scheme, right? Under this scheme, government has basically empaneled a lot of facilitators, advocates for trademarks and patent agents for filing of patents and design patents and everything. So what happens under this scheme is, SIPP scheme is that any startup which is recognized by the government of India can file a patent or a trademark or a design patent by only paying a discounted government fees. The professional fee will be paid directly by the government to the facilitator. Like I am a registered facilitator for the patents as well as design patents and trademarks. So if any recognized startup comes to you and asks for your assistance in filing of the patents and trademarks, what you can do is you can get connected with a facilitator like me, and the professional fees will come from the government. The client is not supposed to pay it. So in case you have a client who's not financially capable of making the expenses in the current situation, such schemes are really beneficial to retain a client and get his work done, right? Apart from that, there is another scheme called this intellectual property facilitation by MSME, right? So MSME is not giving upfront, but they are giving you a reimbursement. So any of your clients in the past, if they have filed and successfully registered a trademark, they are entitled to a reimbursement to the extent of 10,000 rupees per trademark. And if they've filed a patent, which is registered in India, they're entitled to a reimbursement of 1 lakh rupees. And if they've filed an international, patent in more than one countries globally, then they are entitled for a reimbursement of up to 5 lakh rupees, right? So this is a major scheme which government has floated, and now it is also possible to take benefits of this. So what we can do is, in these times with clients having cash crunch and a lot of they are refraining from spending on such tasks like trademarks and intellectual property, which is although very important, and we'll cover why they are important later. They can be told about these schemes, and if they can financially benefit out of them, I think you'll get a lot of brownie points from your client, because you have told them about these schemes, and if they benefit financially out of it, nothing like it, right? So that's the start. So just remember that there's an MSME scheme floated and there's a startup scheme floated, which you can tell your clients and they can benefit out of it. Now let's come to the basics, right? Let me give you a brief idea of what the intellectual property is and what types of intellectual properties are there and why it is important, right? So if we go backwards, why it is important, I always advise my clients in a very simple line: anything which you feel is worth being copied, right, is worth protecting. So a client can wonder, what shall he protect and what shall he not protect? बहुत simple answer है. There is no doubts about it. You can simply tell the client, whatever intellectual property you have created, your brand name, any new design, any new product, or any new technology, any new invention, which you feel has the potential of creating such an impact in the market that people would try to copy it. If he feels like that, then it is worth protecting it. Then it is worth spending some money and time and effort on protecting it, right? So intellectual property, friends, it's a very, very self-explanatory term. Anything which is created by human intellect is intellectual property, right? So if we talk about the various types of intellectual property, so there are mainly broadly 5 types. Patents, that is basically given for any technical invention. Then you have trademarks, that basically covers your brand name, your identity in the market. Then there is a design patent. So design patent is basically given for only the aesthetic aspect, wherein uh, it appeals to the eye, it's novel, but there is no utility of that design. If the design patent also has a utility, then it can qualify for a normal patent. So that's the major difference. Then there are geographical indications, right? Like champagne, you have Assam tea, you have Darjeeling tea. So something which has gained importance because of its geographical origin is under geographical indications, or we can call it GIs also. Like for instance, Basmati is a major GI. Assam tea, Darjeeling tea, I've already told you. Banarsi silk. So all these are kinds of GIs. So any trade associations or local trade associations who have a certain kind of a product who has gained tremendous reputation for their regional expertise, you can also suggest them for going for a GI. And last but not the least, it is a copyright. So copyright is basically on any creative effort. Nowadays, even the softwares are also subject matter of a copyright, because the source code is covered under a kind of a literary copyright. Uh, and that's the most easy and most readily available protection for any software code, and that's how copyright these days is becoming very important. Otherwise, since ages, copyright has been protecting any literary work, any paintings, any work of art, any sound recordings, any lyrics or song or uh, that type of work is being protected, any cinematographic film. So all those are the subject matters of the copyright, right? So let's first talk about the durations, the differences of these. Right. First is a patent. Patent you get only for 20 years. The date of filing, the clock starts, and till 20 years you basically get your patent protection. It's given to the inventor for disclosing the invention to the market, to the public. So something which was not known to the public is being disclosed to the public, and in return the inventor is getting an exclusivity for 20 years. Here the exclusivity is basically the inventor is given a negative right. He is being given a negative right. That means he is given a right to exclude others from manufacturing, selling, trading in, or using his invention without his permission. So if somebody is infringing it, he's supposed to go and sue him, right? He's supposed to and he's entitled to go and sue him and claim for damages. So he's given a negative right to exclude others. He can exercise that right by filing an infringement suit. So that's for patents. If we move to the trademarks, friends, there is no limit, no time limit. You register a trademark, it is valid for 10 years. You can renew it, and you can renew it till perpetuity. So every 10 years, keep renewing it. Don't forget to renew it in time. Otherwise, it will lapse and you'll have to file afresh. But if you keep renewing it in time, you can renew it for even 1,000 years or till perpetuity. There's no limit to the trademark's time duration, right? So trademarks is, I think, is the most known and most readily generally professionals have a detailed knowledge of a trademark. So trademark is anything which distinguishes the product of a particular manufacturer or a service of a particular service provider from others in the market. So it's a identity for that service provider or a trader or a manufacturer in the market, which the customer recognizes. So the customer, after the Industrial Revolution, does not really knows who's the promoter of every country, every company or a product. They generally relate to that brand. Like we all would have a specific preference that I like Adidas shoes or I like Nike shoes. or I like Reebok shoes, but we don't really know who owns these brands, right? We don't really care about who's the owner of Adidas, who's the owner of Nike. So after the industrial revolution, it's the brand which has its own identity, and people, the customers, connect to that brand. So that is your trademark, and it's your identity in the market when you're in business. Third is your design patents. So design patents are for the aesthetics. For example, you have when we have normal phones with buttons. Apple was the first company to come out with a touchscreen phone without any button. So that was a new design uh, scheme, right? So they also had a patent for it. But then after that patent has expired, now different companies are coming out with different designs of that touchscreen phone. So now only the design function, only the design is protected, not the technology behind it. Similarly, like for any new models in the cars, right? So generally, you see any company launches an automobile, they have a particular design for it, and nobody else can copy it. So the timeline for a design protection granted under the Indian law is 10 years, and it can be extended up to 5 years once. So in total, maximum time which you can get for a design is 15 years. After that, it becomes open source, anybody can copy it, right? So designs is also, if you talk about any handicrafts or any bottle shapes or any textiles, like as in any fashion designer designs a particular garment or an apparel. So all those are subject matters of design patent. Design patent is also now patents, designs, and trademarks, which the three items which I have covered, all of them are covered under the Startup India Intellectual Property Scheme. So if you have any person who's not in a position right now but is a startup, and even if I think you yourself or maybe I can be contacted, we can also assist someone in getting recognized as a startup. It's a very simple process, or registered as an MSME. So both are very simple processes. It's a government website wherein you have to go and fill out a form and give in the details. If you are qualifying with the criteria, you can get yourself recognized. And it's a very, very fast process. Generally, which the companies I have assisted, they have got their startup registration certificate within a week or so, right? So these are the three major types of intellectual property which the patent office deals with. Now there is a copyright office, and GI is also covered by the patent office itself. Patent, that's the main. So these are the three things which an individual client will like to file apart from copyrights. GI is for a group. So geographical indication, as I told you, again, geographical indication, there is no time limit. It can be renewed and it can continue till perpetuity. But there has to be sufficient evidence to be produced that, okay, this particular product from this particular region has gained a reputation in the market. So it's after you have gained a reputation, you can claim that, right? Not just by starting it. So geographical indication, India is again full of Kanjivaram silk, your Banaras silk, your say Mysore silk or Mysore sandal products, your Assam tea, your Darjeeling tea, your Basmati rice. So all these are examples of GIs in our country. And similarly, there are so many regional products which have tremendous reputation in our country, because our country has been producing so many handicrafts and so many products that the particular districts, at least in UP, I can tell you, each district is famous for a particular product. You take up any district, they will have a product of their own, which they have excelled into, and they've become a hub of manufacturing it, and they have over the years gained tremendous specialization in it. So such clients can be assisted with the filing of a GI, and then this thing can actually promote their product globally and can help them demand a premium for their expertise and their specialty. Right? That's for the GI. And now we come to the copyright. Copyright is another kind of protection in the intellectual property, and it's the simplest to register and the longest term of protection, apart from those which are protectable till perpetuity, like trademark and GI. Patents are for 20 years and design patents are maximum for 15 years. But copyright, you get life of the author plus 60 years. And most of these intellectual properties, GI is obviously global, but trademarks and your patents and your industrial designs are national legislations. So if you register in India, that's valid only in India. And if you intend to register in any other country, you have to, as per the international treaties, within a certain time limit or through a PCT application with an enhanced time limit, you have to go file in every country. It's not that you've got a registration for a trademark in India, it will become valid in US also. No, if you want to get a protection in US, you have to file for a trademark in US also. Similarly for patents and industrial designs. Trademarks, you don't have a time limit because trademarks are valid for perpetuity, but patent design patents and patents have a time limit. If it's a convention application, there are two methods. One is a convention application and one is a PCT application. So convention application, you have to file within 12 months. And PCT application, you get 30 months timeline to file across the countries you designate in your PCT application, right? So there's a timeline and you have to file in every country. But copyrights, what we were talking about, copyright you register in one country, and because of an international treaty, you get protection in almost all the countries across the globes that are signatory to that treaty, right? Copyright again is a very clerical process. You file it, and if your application is in order, they'll grant you a certificate. Trademarks and patents and design patents and GIs, you file it, you will face objections. This entire process, I'll show you the flow chart and discuss every step involved. But copyright is a very, very simple clerical process. If your application is in order and there's nothing missing, whatever is required in the form to be filled, and any documents which are required, then you get your copyright straight away. And copyright, there's one more interesting fact about a copyright. So a copyright, even without registration, even if you don't go for registration in the copyright, the moment you create something, you reduce it to a tangible form. Suppose you say you wrote a poem. The moment you wrote it on a piece of paper, you have a copyright in it. Getting it registered with the Copyright Office will only give you a procedural benefit. If I have to explain it in detail, for example, you've got a registered copyright for a poem written by you, and vis-a-vis you have a copyright which subsists automatically when you have reduced the poem to writing, right? Suppose tomorrow somebody copies it and infringes it and commercially utilizes it without giving you any royalty or your recognition or say your permission, right? If you have a registered certificate, you can go to the court, you can file an infringement suit and tell the court, see, this is my registration certificate. I have a valid copyright registration subsisting for this particular work, and this fellow has infringed my rights. The court will presume that you have a copyright subsisting. However, if you have not got it registered, you'll have to first lead your evidence in court and prove to the satisfaction of the court that you have a subsisting copyright in this particular poem, and then you proceed ahead, right? So that's the only procedural flaw. Apart from that, when there is a case of counterfeit, see, it's very, very common in India that you have counterfeit products. Like all these big brands sell their products obviously at a premium because of the intellectual property involved and their costs involved, the quality they give. And then there are these counterfeit sellers who sell these products at the roadsides or other gray markets for very, very, like a very small fraction of what the price a brand would charge, right? So such counterfeit products, if you have a registered copyright, you can directly conduct a raid by involving the local police. You don't need to go to a court if you have a copyright in it. However, if you don't have a copyright, then you have to go to the court and follow a different procedure. So registering a copyright is more of a procedural benefit vis-a-vis giving you a substantive right. right? So when you file a trademark, you're given a substantive right. Until unless you have a trademark, you cannot call yourself a owner of a trademark for a particular brand name. But if you have a poem written on in writing, you can call yourself to be a copyright owner in it. However, to enforce that right in court, the procedure will be much easier if you get it registered from the Copyright Office. All right. So as I said, I will be showing you the processes. Okay. So let me first of all tell you about the websites, right? So I'll first share a screen with you, which is the website for intellectual property office, and this is the. Am I able to share the screen? Friends, can you see the screen?
Yes, it's visible.
Okay. So here you see the IP India website, and this is basically the different types, as I told you, patents, designs, trademarks, GIs. This is a institute by the government in Nagpur. So anybody, if they want a detailed training, they can go and attend a course there. So this is the website, ipindia.nic.in, right? And now it's very, very fast, very, very simple, very, very comprehensive. It's all online. So thanks to the government, they've made it all online. We trademark attorneys are still able to function from our homes during the COVID periods also. As far as our litigation practice was concerned, it was shut down mostly, and it was reduced to a very small fraction because video conferencing, of course, was happening in courts, but to a very small level. But IP filings is going on as such, right? So this is the trademarks. This is the comprehensive e-filing link for the trademarks. So nowadays we log into this comprehensive e-filing link and file everything from here. So this is a public search also available. So if a client comes in and he asks how he wants to file a trademark and wants to know whether or not the trademark is already registered or not. So then this is the link which you need to check. You put the trademark here, put the class here, do a search, and you can, based on that, advise him whether or not it is advisable to go ahead and file that particular trademark in that class or not. Apart from that, similarly for patents and for designs, one more important information. Nowadays, if you file a trademark or a patent or a designs application online, you get a 10% discount on the government fees. So it's always advisable to file it online.
Okay. Bhavya, how to find the class? As you told me, we need to put the name and class.
Name and class. Okay, so that's also very simple. You come to this trademarks, then you come to classification of related links. You come to classification of goods and services, right?
Okay.
So this will take you to a website.
Hmm.
So this is a central website for all the trademark offices across the globe. Europe. This is by European Trademark Office. So this is euipo.europa.eu. So the best method to reach this place is through the Indian Trademark website. You go to the trademarks, then related links, and then classification. Right here, you put a term. So Sangam, since you just said, tell me any product which you want to check which class it will fall in. Any product.
Shoes.
So you put it here, and then you'll get the results. So here are the results. So class 25 is shoes, right? Now it will give you a detail: rugby shoes, football shoes, soccer shoes. Now dog shoes, if you talk about, is in a different class. Now that's class 18. However, others are in class 25. Now orthopedic shoes, these are basically specialized shoes by doctors in any orthopedic. That is also a different class, class 10. But otherwise, most of the shoes are covered in class 25, right?
Right.
And this is a very comprehensive website. It also tells you any related products. So chemicals for leather is in class 1, then leather and shoe cleaning polish is in class 3, lubricants and industrial gases. So this side of the window, it will give you further detailed information. It's a very comprehensive website, and everything is made available at very easily. All right. So similarly, I'll show you. This is another thing. Generally, a client comes to you and tells you that I filed a trademark, but it is pending. I'm not being responded by a professional. So this is the trademark status. I'll show you again. Trademarks, related links, trademark status. Here you can check the status of any trademark filed. So this screen comes. You have to click the trademark application, registered mark. Then there are two options. One is national and one is international. Okay, so this is also very interesting. See, nowadays, there is something known as a Madrid protocol. And under the Madrid protocol, you can file, after filing an Indian application, you can file a Madrid application designating a number of countries where you want to register your trademark. And as per the Madrid agreement, under which this Madrid protocol is established, all the countries where you designate, your trademark application will get filed through this common application. And all those countries will get a limited time frame to raise an objection. So if they raise an objection within that limited time frame, you'll have to engage a local lawyer in that country and handle those objections. However, if they don't raise any objection, then you are deemed to be granted a trademark in that country. You get a trademark. And if your application is good, maybe they don't want to register, they don't want to raise a objection, and they grant you a trademark without any objection. So that's again this that kind of applications can be clicked here for. And national applications, you just have to select national, put the trademark application number here, put this verification code here, whatever this thing, and you can view the status of any trademark application. Right? I'll not like to open any application here, but this is a very, very easy method of looking at the trademark application of any status of any trademark application filed. All right. So similarly, we have e-filing for patents. So patents is a little more technical area, right? So comprehensive e-filing, you can comprehensive e-file patents, you can e-file trademarks, you can e-file designs, you can also e-file geographical indications. So everything is very, very easy. Now again, status you want to check, you can check the status for patents, you can check the status for designs, you can check the status for trademarks, you can also check the status for geographical indications, right? Again, public search, you can do it for patents, you can do it for trademarks, you can do it for designs. Okay. So very, very easy, but patents being a little technical field, wherein to understand the invention, you need a person who's skilled in the art. See, if it's a pharma invention, you need a person who's having good knowledge of pharmaceuticals to understand it and process it. So in that case, you should involve a subject matter expert or a patent agent and then proceed. Otherwise, for trademarks and designs, you can go ahead and give a basic advice, and if something is required, some detailed advice is there, or some it's a contentious matter, then you can involve an expert. Again, I would like to also show copyrights. So copyright is again copyright.nic, copyright.gov.in. So this is a website for copyright applications. Again, you can do e-filing here. So it's a very simple login again, and then you file a copyright application. You pay the fees also online. However, in copyrights, you have to take a printout of the application, get it signed by the client, and send it physically also. In trademarks and patents and design patents, you don't have to do any physical filing anymore. But copyright, first you file electronically, and then you sign and send a physical copy also. Right. So that's about it. So let's first look at the workflow of a copyright application. This is the workflow of a copyright application. So once you file the application, you're issued a diary number. As I told you, 30 days mandatory waiting for objections. The office will give you any objections, and then the objections might be there, or there might be no objections. Right? If there are no objection by the examiner, then it is scrutinized. Once it is scrutinized, there can be a discrepancy or no discrepancy. So first is basically whether your application is in order, and then it's the scrutiny, which means all the ingredients are there or not, right? Suppose if you want to file a copyright for something which is a trademark, or which can be used for any commercial products, right? So then you need an NOC from the trademarks office. So if you don't attach that NOC, it will be a discrepancy will be raised here by the copyright office, right? So such things are to be there intact when you file a copyright. So if there is a discrepancy, then you'll get a discrepancy letter. If there is no discrepancy, then your registration will be approved, and your registration certificate will be issued. Okay. And then similarly, if there is an objection, they'll send you a letter. Then you'll reply. Maybe there's a hearing or not. Then that objection might be allowed, cured, whatever. And then the application goes to scrutiny. And then again the process is followed. If there is a discrepancy, again given a chance to reply to it. And then after reply, you can also cure it. So majorly I'll tell you what major discrepancy people leave in filing a copyright. When you file a copyright for a software source code, most of the people don't understand that when you file for a software, a copyright, what you get a copyright for is the source code. And you're required by the Copyright Office to file both source code and the object code. So people don't file the source code and the object code, and then there is a discrepancy later. So source code is basically the code which the software engineer has written for running of that software. And then there is another object code. Object code is nothing but machine readable form of the source code. So say you code it in any language, and then basically whatever language it is, there is a processor which converts that language into machine readable. So if it is binary, it will be in 0101. So that is created by the by a software itself. The source code is converted into an object code. So you need to file both of them with the Copyright Office. Otherwise, the application will be there will be a discrepancy raised in the application, right? Apart from that, what else you need to consider is whenever you file something which is subject matter of a trademark, then you have to be very sure of having an NOC from the Trademark Office and attaching it to the application. Apart from that, one more important thing which you should keep in mind. So there is a overlap or say interaction between a design patent and a copyright. So anything which is subject matter of a design patent. For example, it is a water bottle or a shoe, or say a garment. Any designer like Rohit Bal designs a sherwani, right? So that's the subject matter of copyright also. That's the subject matter of a design patent also. So copyright in such products wherein the design the product is covered under designs. For example, a painting is not covered under designs, or a song is not covered under designs, right? This is not applicable on such products. But what is covered under designs is again a shoe or an apparel. So the moment you create 50th copy, so if say a famous fashion designer designs an apparel and creates 50 copies of that particular garment, the copyright is gone. Then he's supposed to get it protected if he wants to under the designs patent. But then design patent has to be filed before the product is launched in the market. So you can advise the client that if you want to go for mass production of such products which are covered under design patent, then you should first seek protection under designs. So a lot of shoe manufacturers, a lot of fashion designers who are into mass production are not aware of this fact, and they think that they'll get protection under copyright, but they don't get it. The moment they create 50th copy, it is gone. And since they have not filed a design patent before launching it in the market, they cannot now get a design patent protection also. So if they want to go for mass production, they should first file a design patent and then launch it in the market, or publish it in any journal, or display it in any fashion show. And if they want a exclusive production less than 50 copies, then they are protected under copyright. Then they don't need to go for a design patent. All right, so that's another aspect which is, I think, very important when you are advising any client regarding copyrights and designs, right? Now let's go for the patent and trademark procedures. So I think let's do an easy one. Let's go first with the trademarks, and most of you are also familiar with the trademarks. Okay. So, Sargam, I believe the flowchart is available. It's
yes, it's available.
Okay. So this is the trademarks flowchart. So this is the first step: receipt of application, data entry, and digitization at branch offices. So this flowchart is basically when is also covering physical filing. So nowadays, when we do online filing, the data entry and digitization part is done by us only, and the application directly gets filed, right? Once the application is filed, the examination of the application takes place. So when the application is examined, there can be two events. One is uh, there can be an objection. There can be no objections, right? If there are no objections, simply it will go for publication and wait for the third party opposition. In case there are objections, then the objection will be raised and we'll have to file a response, and then it will go to the journal publication, right? So once this process, there can also be a show cause hearing. It's also mentioned here. If they are not satisfied with the written response, there'll be a show cause hearing. It can go to the trademark journal for publication, and then there is a statutory period of 4 months. Once the application is published, there's a statutory period of 4 months where any third party can oppose it. And if the application is opposed, then the opposition will proceed, and whatever is the outcome of the opposition, based on that, it will get registered or not. And it can go also into an appeal before the Intellectual Property Appellate Board, that's IPAB. Otherwise, there is no opposition, then you can get a certificate in the 5th month after the completion of the 4 months. In the 5th month, you get a certificate. So this is a very simple process, basically, for the trademarks. However, one thing which I would like to point out to all the professionals is, if you have a client whose trademarks are very, very valuable, he can also give you a watch and ward service. So trademark office publishes a journal every week, and people with very valuable trademarks would like a professional to do a watch on the journal, whether or not any similar or conflicting trademark is accepted by the office. And if it is so, then they would like to oppose it within 4 months. So that's a way wherein you can, benefit the clients, enable them protect their intellectual property, and also generate work for yourself. So if they are willing to, you can give them a watch and ward service. Have a person or a resource from your office look at the journal every week. It's a very voluminous journal. Like, it's sometimes it runs into even 10,000 pages. Generally, it is more than 1,000 pages, right? So every week it is there. So it has to be looked into. So it's a task which you can also ask your clients to assign. Now going forward, let's look at the patents. So again, Shargam, it's you can view the patents flowchart now, right?
Yes, I can.
So this is the filing. After filing, 18 months period till publication of the application in the journal. So this is very different from trademarks. Trademarks, you get a publication only when the application gets accepted, and you get to file a opposition. Any third party can file a opposition only when the application gets accepted. But here, the moment you file it, the first step patent office will take is publish it. So publication, once it is done, any party can also file a pre-grant opposition. So before even the office gets involved, people can get involved. Apart from filing, you have to file a request for examination separately. When you file a patent, you are the one who has to file a request for examination. If you don't file, any third party can also file for a request for examination on your behalf, because they don't want your application to remain pending, right? So request for examination has to be filed within 48 months of filing the patent application. Otherwise, your application will get abandoned. Once the request for examination has been filed, the office will issue a first examination report. After the examination report is issued, you have to respond to the report, and based on that response, you can be granted or you can be asked to amend your patent application, and that's a process. So this is a hearing, it can also be refused. So similarly, when it was published, if there's a pre-grant opposition, again this is the same process. Initial procedure, hearing, decision may be refused or it may be granted. So once it is granted, then your grant is notified in a journal, and then there's a possibility of a post-grant opposition also. So again, post-grant opposition, the initial procedure, hearing, decision, and can be refused and can be granted. So there are two ways a patent application can be opposed by a third party. One is a pre-grant opposition, and then there is a post-grant opposition. Apart from this, there is this is the national patent procedure. So if you want to file and register a patent in India, this is the procedure you follow, right? There is an additional, like in trademarks, there's a Madrid protocol. In patents, there is a patent cooperation treaty. But that's a little different from the Madrid protocol. Madrid protocol, you file it, and if the international offices don't raise an objection, your trademark is deemed registered, right? But here in PCT, you have to file a PCT application within 12 months of filing the original application in India. And after filing the PCT also, from the date of filing of the original application in India, you have to file application in all the countries you're interested, and you designate in your PCT within 30 months. So once you file it, then you have to follow the procedure in that country, and then you have to obtain a grant. So you have to mandatorily engage a professional whenever you enter the national phase of a particular country. Whereas for Madrid, for trademarks, you are only required to engage a professional from any foreign country if there is an objection, right? So trademarks, again, much simpler. Patents, again, much complicated as compared to the trademarks. So having shared all this, I think I have covered most of the aspects, and I would like the audience or anyone from you to ask any questions, or tell me any topic which they want me to cover in detail, because I think I've given a very basic introduction of the procedure and how the things are, what the timelines are, and how it proceeds. Apart from this, if they want to know any details, I would like to share.
Yeah, Bhavya, we got one question from our audience.
Yeah.
They want to know that you told me there is a life of a trademark like 10 years, 15 years. You told. So you told it will start from day one when it is filed, because generally in trademark we get year, 2 years also to get the final certificate.
Right. So I'll repeat myself. Trademarks is valid for 10 years, and you can renew it till perpetuity. There is no limit. Right?
Okay.
The date you file it.
Date of filing application.
Date of filing of the application, 10-year period counts from date of filing.
Even
you might even take 9 years to get it registered. Okay. But you have to then renew it within the year just in a year after you get the certificate. So your period of 10 years starts from the date of filing, always.
Okay.
You have to renew
And
it.
renewal period is also again for 10 years.
And
Yeah, you renew it. It's again for 10 years, and then you can again renew it. So it's still perpetuity. Nobody stops you, provided you renew it, right? And there was a interesting case, Sargam here. So my senior, where I started working just after my college, had filed a trademark application, and he had 30 years of experience, and that was one of his initial applications which he had filed, and we got a registration after 30 years. And we had to, after we got a registration certificate, we had to file a renewal for the
Twice.
previous 2 terms also, and at the rate prevailing at that time. So we filed a renewal and paid the fees for 3 terms in a single go. So
So the patent was granted retrospectively.
yes.
so it was granted pretty late, but then once you have the grant, you have to have the renewal in place, right? If you don't file it, then it will get expired. So with that senior, I got the opportunity to handle so many trademarks. So I've seen almost such rare cases, and I can tell you on that. So even if you get it after 10 years, you have to immediately, you get a period of 6 months, you have to immediately file a renewal for the period you are running. So it always runs from the date of filing.
Okay.
Similarly for patents also.
Okay. Also put some light on the matter how to deal with the objections, because if we file 10 trademarks and out of that at least 8 and 9 are just pending in the objections. So this is one of the major issues of our participant, how to deal with the objection. First thing, how we can file our trademark application so that we get less objection, and even if we get the objection, then how to handle that professionally.
Okay, Sargam, very good question and very pertinent question. First is, I'll tell you all that use is the best weapon or tool in your armory when you're dealing with trademarks. If you can show to the examiner that you have extensive use, you're using it for 10 years, 20 years, and your turnover is sizable and you have a reputation in the market, if you can prove that, it can cure all defects. It can cure anything, any objection raised by the examiner. That's your best tool. Always try to ask the client what evidence he can give if you're supposed to prove the use. Always ask him to keep intact all the invoices, any registrations like VAT, sales tax done in the past, or any publications in the paper, any advertisements. So all those things are very, very material when it comes to proving it in the registry, right?
Okay.
Always try to claim a user. You have to file an affidavit at the time of filing an application. Always try to claim a user at the time of filing an application. If you file it without claiming a user, you say it's proposed to be used, then later on you cannot go back and change it. And that's the most common mistake made in filing a trademark application.
How generally it asks you from how many time you are using. So
Yes.
is it a suggested time limit?
Yeah. So there's a very, very specific column called user date. So you have to give a specific date. We are using it from this date, and you should have an evidence to support that claim. Yes, we are using it from that date, and you have to file an affidavit now at the time of filing the application also that I'm claiming to be a user since then, and it's a continuous, uninterrupted user.
Okay.
It's not that you used it for 1 year in 1960 and now you claim that I'm using it for 50 years. It has to be continuous. So you have been using it since then, so for 60 years without any interruption from any angle, any corner, and you've not stopped your business in between. So that kind of a claim is to be made, and it has to be backed by evidence. That's the best use. That's the best tool you have. Apart from that, see, in trademarks, generally 95% of the times there are two objections. One is section 9 and one is section 11 of the Trademarks Act. Section 9 can be subdivided into two. One is that the mark is descriptive. Kind, quality, quantity, like tasty for food, sweet for sweets, such objections, it's generic. It's not something which is distinct for a particular mark, right? Second is it is non-distinctive. Kind and quality, it is one is descriptive, then the other is it's not distinctive. It's very generic, like say it's a name of a person that's not registrable as per section 9, right? So people generally try and file, protect their last names, so that under section 9, last name is something very generic. It's not specific, or it does not create any distinction. Again, all these objections raised by the office can be overcame by claiming and proving that you have a long-standing use, right? That's the best tool. Section 9, you can overcome any objection under section 9 by proving to the examiner that you have a long-standing use.
Okay.
So section 9, you have to say how your application is distinctive and how it is identified in the market, that the customer knows this particular product by this particular name, and that's how you are entitled for this particular trademark. So that's your major answer to any objection under section 9, right? Section 11 is a very, very specific objection that they cite. So these are the applications which are conflicting with your application. These are the marks already granted. To be very, very honest, you should first do a public search to avoid section 11. Having done that, even if still there are objections under section 11, then you should go and look into the details. You should check each and every cited application. Generally, you'll find them they are abandoned. They have not claimed to be a user, and you have. So that's an additional advantage you have. And then you can reply that I am a prior user, and then that's how I have a better title, and I am entitled to grant, and he's not entitled to remain on the register. And then you can file a rectification against him, have him deleted from the register, and get your application registered. So whosoever has the earlier use claimed and provable has a better title. Third is you distinguish yourself. You say, no, this is different and we are different. That's also there. Generally, trademark office will cite anything which they think is similar, but it might not be similar, right? Happens. So that's your third response to it. So these are the general lines on which you should respond. However, I've seen that a lot of professionals are just, in a habit of using a template and just filing it. No, we are distinct. You should never do that. Once you say on record that I am different from this particular cited mark, later on you'll never be able to sue anyone for infringement using that kind of a word. Today you say you're different, tomorrow it will count as an estoppel in court against you, that there you said it was different, now you say it's same and you're infringing. So, you have to be very careful at this prosecution stage. And most of the infringement suits, when we handle, we bring out the prosecution history. A brand sues us, you are similar, and we say, no, you cannot say that, because while prosecuting your trademark application, you said that this cited application is different, not similar. So now how can you turn around and say something different? So that's one thing which you need to be very, very sure of.
Bhavya, my another question is, sometime there is a gap between getting the objection or filing the application, might be 6 months or 8 month time also. So sometimes the person who filed the objection didn't get the physical notice, and sometimes email address is also from some attorney and other person who filed the original application. So how to trace?
So, yeah, Sargam, I'll tell you, this thing is now.
My question is not complete. I am just adding one more twist in it. Suppose
Okay.
I am unable to find the examination report or notice, or that date is already over. Suppose examiner want physical hearing and that date is already over. In that case, what remedy is available with the applicant?
See, once it is abandoned, nowadays it's very tough to revive it.
Okay.
Now those days are gone. I'll be very honest with you. Now, if you file a trademark application, you'll get an objection within a month. I think the Honorable then Law Minister, Mr. Arun Jaitley, he had revamped the IP office in a very, very commendable manner. They've recruited a lot of examiners, and the process is very, very fast now. Earlier, when you filed a trademark application, it used to take 2 years for them to generate an objection, and then again 2 years to send you a physical notice. Now it's generated within a month. It's mandatory for you to give an email for service. Whatever email you give for service, if it is delivered to that, it is counted as a service. Now, if it is an advocate's email and he didn't communicate, that's none of trademark office's headache. You should not have given his email ID at the time of filing. You should have given your own. And secondly, everything is available online. You get into that trademark status link and bring out the status. You get your examination report there. There's no hiding of the examination report. They upload it the moment they generate it.
Okay.
So
by the way, once it's abandoned, then we can file it again. Am I right?
Once it is abandoned, you have to file a fresh. Yes.
Okay, the thing is only that we are required to pay common fees again. There is nothing else. Okay.
Abandoned is as good as non-existing on the trademark register.
Okay. So one of our very good friends, CA Vikas Anand, want to know what are the steps available with us. Our brand name is under objection. So I think you have already discussed in detail. Firstly, we have to find out the exact reasons. What are the exact reason and under which section it covers, and we should wait for and file the online reply. And even then, if it comes for the hearing, then we need to visit the department and satisfy with them all the necessary documents. Is it?
I would add one more thing here. Nowadays, the department, at least Delhi office, is holding VC hearings also. So you can do that also.
Okay. So also guide Bhavya, is the applicant can go itself to attend the hearing, or is it require some attorney to attend the hearing?
So everything the applicant can do himself. He can file it. He can attend the hearing also. He can file the reply also. There's nothing which stops him from representing himself before the office. For that matter, Sangam, even the Supreme Court, any person go as a party in person and argue his court, even in the Supreme Court, even the highest court of the land in our country, nobody is barred. But it is always advisable to have a professional represent you to the best of your interest and advice, because they are very well versed with the nuances and the loopholes, which you might not be, right? So if you can get a good professional representation, that is always advisable. However, legally speaking, there is no bar against anyone from representing himself before the trademark office, before the intellectual property appellate board, the high court, or the Supreme Court itself, right? That's how the law is.
Okay. Shomji, do you want to ask some question?
I think most of the queries that I could have thought of have already been taken care of by Bhavya in his presentation.
Yeah. Truly speaking, it was a very practical presentation, and it definitely helped to all the professionals to work in IPR, because sometimes the session becomes theoretical also, but in today's session I found it is very practical, and it really definitely helped. And I will also see it tomorrow morning again, the complete session, to get to update my IPR skills, so I can give services to my clients in this regard.
Correct.
So Shon, do you want to speak on the GST part on the IPR? Do you want?
Yeah, so I'll speak for a few minutes regarding the GST applicability on patents and copyrights and trademarks. So the main issue that the assessees and the people who are filing for the patents face is that whether patents is a goods or is it a service. So whether it is patents or is it a issue of patents rights, which converts it into a service. So first of all, we have to see the definition of goods, which means every kind of movable property other than actionable claims and money, which is defined in section 2 of the CGST Act. And services means broadly anything other than goods, money and securities. So if we are able to find out what goods is, we can find out what services is, because services is anything other than goods. So we have to first analyze section 7, whether it is a supply or not. And once it is a supply, we should go to schedule 2, which tells you whether the particular supply needs to be followed as a goods or a service. So in schedule 2 clause 5c, we can find the words mentioned that temporary transfer or permitting the use or enjoyment of any intellectual property right is a service. Hence, it has been deemed in para 5 of schedule 2 of CGST Act 2017 that transfer of intellectual property rights is a service. So we all know that patent falls within the definition of intellectual property rights, broadly speaking. And the same view has been upheld by the Supreme Court in Vikas Sales Corporation versus Commissioner 1996, that it is a service. The same view has also been upheld by the FAQ of CBIC issued on 15 December 2018, where it has been said that transfer of right to use goods shall be treated as supply of service because there is no transfer of title in such supplies. Such transactions are specifically treated as supply of service in Schedule 2. Then the question arises, what will be the rate of such transfer? Then under section 9, read with notification number 11 by 2017, we can find the mentions of words under heading 9973 as the temporary or permanent transfer or permitting the use or enjoyment of intellectual property rights in respect of goods other than information and technology service software is taxed at 6%. 6% CGST, 6% SGST, making it 12%. And it has also been mentioned that temporary or permanent transfer or permitting the use or enjoyment of intellectual property rights in respect of information and technology software is taxable at 9%, CGST and SGST each. So we have to first analyze heading 9973 also, and carefully we have to identify that it falls in 12% bracket or 18% bracket. And one more important thing is whether it is taxable under forward charge or reverse charge. So if we see notification number 13 by 2017 CGST, it has been mentioned that category of supply of service, if it is by an author, music composer, photographer, artist, or the like, by way of transfer or permitting the use or enjoyment of a copyright covered under clause A of subsection 1 of section 13 of the Copyrights Act, relating to original literary, dramatic, musical, or artistic work to a publisher or to a music company or to a producer or the like, then such kind of service will fall under reverse charge. And who will pay the reverse charge? That is the tax from his own pocket. He would be publisher or the music company, producer, or the like located in the taxable territory. We all know that in such cases, the supplier of service is always the author who's writing the books, or the music composer who's composing the music, or the photographer, or the artist who's making the paintings. But even though these people are the supplier of service, they will not pay GST under forward charge. The liability to pay GST falls in the hands of the recipient because of notification number 13. And sometimes a query comes that the author or the publisher sometimes doesn't pay the royalty to the authors. They sometimes pay the royalty to the heirs of the authors, or they sometimes pay the royalty to the university or to a domestic or a foreign company. Then in such case, will publishers still be liable to pay GST under reverse charge? The answer still remains yes, because it is immaterial as to who is the recipient of the consideration. The liability still falls in the hands of the publisher. So I think these were the basic things that we should know uh, while understanding patents, copyrights, and trademarks from the point of view of GST.
Thank you, Shomji. So friends, before closing this session, I want to share the contact detail of our today's learner speaker, Advocate Bhavya Goyal. So friends, I think you hope you are visible to see my screen. So here is his mobile number and email ID. Is it visible?
Yeah,
Shomji, is it visible?
yes, it is. It is
Yeah.
visible.
Yeah. So friends, you can get his contact number and email ID. You can contact him for your any kind of query related to IPR. So his number and email ID is here. Let's wait for 10 seconds so the members can write down. Also, friends, I will provide his email ID and phone number in the comment section. You can also check it from there. So, with this note, I want to express my sincere thanks to Bhavya Goyalji and CA Shubham Aggarwal to providing a very beautiful session. Intentionally, I am using the word beautiful because it is very much practical and giving opportunity to our young professionals and to get a new business opportunity. And again, I am speaking session is very practical and it will definitely help the young professional to add a new work in their day-to-day profile. So thank you very much, Bhaveji. Uh, we
Thank you so
hope
much, Sangam. Thank
we
you so much.
hope we get some more session together on different aspects of IPR. And Sumam is also our executive member of our Association of Professionals. Thank you very
It's a
much, Sumam
pleasure.
ji.
It's a pleasure, Sangamji, to be a part of such a renowned association of professionals, headed by none other than you. So it is always a part to be a part of your team, and
Thank you, Sumam ji.
it's a wonderful platform to get associated with professionals like you, Bhavya ji, and learned speakers who come from time to time. And it helps us and helps our vision of disseminating knowledge to our professional brothers.
Yes. So, friend, in this series, we have also start one more thing. On every Wednesday from 12 to 1, we're going to start one live session for 1 hour. It is basically Zoom-based session. In this Zoom-based session, all will you can come and join that session and ask your queries. And we have a team of expert. You can ask your any kind of professional query like GST, income tax, IPR, any company law, any matter FEMA. You can come and ask your query, and we will try to resolve your query on the spot. And if any query is unsolved, and we will revert you as soon as possible. So, friends, in the comment section, I will share you the meeting details. So, I hope the more and more people will join in large number so that they can resolve your query. Any professional can join, whether they are CA, CS, CWA, CA student, like anyone can join that meeting. But friend, limited. We have a limited capacity of 100 only. So I request you join on time so that we can give better service to you all. So with this note, I express again my sincere thanks to Bhaveji and Shubham Aggarwal. And by this note,